Welcome back for part 4 of our intellectual property video series. Our legal English sessions have helped hundreds of lawyers around the world, and I hope that they're starting to help you too. In this part 4, we're going to be talking about patent infringement. What happens when you have a patent and somebody else tries to use it? My name's Jeff Keiser. I am a lawyer from the United States, and I've worked on big cases over my 15-year career. But most of all, I'm a legal English teacher, and I've helped hundreds of lawyers from all over the world be better at using English, both in speaking and in writing. My goal always is to help you make your arguments in the most effective way possible. So, in American law, in 35 U.S.C. section 271A, the U.S. law has defined patent infringement as whoever, without authority, makes, uses, offers to sell, or sells any patented invention within the United States, or imports into the United States any patented invention during the term of the patent, is guilty of patent infringement. Whew, that's a mouthful. Like most statutory law, they're no fun to read. But I think we can understand what this really means, is that if you don't have authority and you use patented technology, you're infringing on that patent. So the definition of infringement is the unauthorized use of protected material violating the exclusive rights of the IP holder. And let's think about that just for a second. The exclusive rights. That's an important term in this discussion because that means that the IP holder is the only person that can use that intellectual property. Now, there are 2 or 3 real types of infringement. And the easiest one to understand is literal infringement. And that's if you have a patent that has a checklist of 10 items that makes up your device, and somebody else makes something that is exactly the same, that uses all 10 features exactly the same way, that is a literal infringement. And those are the easiest cases in the world to win. You just simply file a complaint with your patent and a description of the product, and you win. It's never that simple, of course, but it's almost that simple. Literal infringement is when you're copying someone else's patented invention. So let's say you have a patent for a desk lamp with 7 features. They are a magnetic base, a flexible gooseneck mounted to the base, a reflector mounted on the end of the gooseneck, an LED bulb mounted to that reflector, an on and off switch, and a control circuit. And then a final one that has a control circuit that keeps the LED lit for 30 minutes before automatically turning it off. I've seen lamps like this. I think they're pretty cool. I think I've had a lamp that almost was like this, maybe not a perfect match, but similar. I'm sure you have seen lamps like that around your house or work and use them frequently. Now, if somebody comes along and builds something with 6 of those features, but not the 7. Let's say that this one is exactly the same in every way, but does not have that automatic off feature. Then we're not talking literal infringement anymore because it doesn't literally infringe. On the other hand, if it has that automatic off feature, then you're in this category and it's really easy. Remember that if another lamp has features 8 through 20 that are different, it still falls into this category because you've copied one device entirely, even if you've added on a few things to try to make it look a little different. Now, the doctrine of equivalence is something that we use to expand that, because most patent infringement is not based on an exact copy. Like, for example, if we took that desk lamp and we replaced the LED bulb with an incandescent old school bulb, it wouldn't literally infringe, even if the effect of it would absolutely be infringement. But we have doctrines that will expand that patent to cover things where it still copies the design, and it still copies 6 out of 7 of the pieces. That doctrine of equivalence will help us prove infringement. This works in my hypothetical because both the LED and the incandescent bulb are functional equivalents. They do the same thing. Sure, one burns a little hotter and produces a different kind of light, but they are substantially the same. They both turn electricity into light. So, if this happened, I believe that any court in the United States would call that infringement of the patent. Okay. Excuse me. That's it for infringement. Believe me, that is a subject that we could talk for hours about, but we don't have hours here. And that is really the end of our patent discussion. So what are they? They're inventions. If you build a new hybrid car that's better than a Tesla, as long as it's not exactly like a Tesla, you're in the world of patent. Next time, we're going to move into trademark law. And I think you'll find this a really interesting discussion. Hope to see you there. Bye-bye.